Let's start off with Judge Middleton. Let's see if he's got a good story about a snowy bridge or something like that.
You had a charge of domestic violence. You were set for a pretrial with the attorney Ross Truckee to represent you on Friday afternoon, this Thursday, December 4th. You failed to appear, he was set to represent you on October 30th. You didn't show up for your hearing on October 30th. The bench warrant issued and you got arrested over the weekend. When did you get arrested?
I was just brought in on Wednesday. I've been in rehab, and I went on my own. I didn't tell anybody I went.
Where'd you get arrested on Wednesday?
At my house.
On Fawn River Road?
No, I wasn't on Fawn River Road. I was on 300 South 4th Street.
Did they come there specifically to arrest you, or did you have just some other reason to have contact with them?
They said they came there because I had bench warrants, and they were shining flashlights in my face and told me to come out front.
All right, well, very good. Get the case back on track. I'm going to set this for a last pretrial with attorney Truckee for this Thursday. He's set to be here that day, 12/4 at 2:00. Bond is now $1,000 cash or surety. You also failed to appear for arraignment in a charge of malicious destruction of property. Take a look at that. That is file number 251958. In that case, the allegation is that you were in the village of Colon and you damaged some vehicle tires which belonged to Katie Brandy's, and you had been in a dating relationship. Injury of more than $200 but less than $1,000. I can attest, having just bought 2 new sets of tires, that a set of 4 tires can be well over $1,000. Anyway, that's the allegation. They allege that it happened on August 30th.
If I may, I did go in and replace all 4 tires. If that means
well, don't say
anything.
any more about it. Show a plea of not guilty. I'm going to appoint attorney Rhonda Ives and set an attorney pretrial for January 1st. I can't go that far out. For December 19th. at 8:30. Bond in that case was also set by the magistrate at $1,000 cash or surety, actually set by Judge Pattison. You did show up for your arraignment. Where did you go to rehab?
In Kalamazoo at Enlightened Recovery.
What's the name of it?
Enlightened Recovery.
Lang's Recovery?
Enlightened.
Oh, Enlightened.
Yes, sir.
Well, that's a plus. All right, and we got one more. File 252303. Charge of retail fraud in the second degree. In that case, it's alleged you were at the Myers store on October 12th, and you stole some stuff, and you had a previous offense, making it a second degree retail fraud. That's punishable by up to a year in jail and a fine of up to $2,000. Excuse me. Hoping before January 1, I won't be sick anymore. Gotta stop hanging around with little kids. All right, I'm gonna show you a plea not guilty on that. Show plea of not guilty. I'm gonna appoint an attorney. Set attorney pretrial again for December 19th. At 8:30. If I code to December 2nd, it's more than 28 days from the day you got arrested. So I'm going to accelerate this up to December 19th. So you got 3 set bond at $1,000 cash or surety. You're not to go to Myers. When did you get out of rehab?
I got out of rehab on I'm just spitballing here. I think it was roughly the 15th.
Of what?
November. I went on November 3rd.
All right. Well, you never bothered to call your lawyers or the court or show up for anything. So now you're sitting in jail. Mr. Truckee represents you in the first case. We'll deal with that this Thursday. Maybe they can address everything on Thursday. The other two
almost half.
Señor, lo que está
a little later. That would be December 19th. All right, Mr. Gowan, you're good to go.
Thank you.
Showing my professional hosting skills right there as I did an accidental switch to another feed. Sorry about that. But now we're going to do a purposeful switch. I'll stay in Michigan. Let's go say good morning to Judge Oakley.
Mr. Bennett, what do you got ready?
The first one would be Chirino, Your Honor, Jorge Diaz.
CHIR.
Got it. Appearances, please.
For the record, Your Honor, James Bennett appearing on behalf of the airport. I believe. Go ahead, ma'am.
Good morning, Your Honor. This is Celine Yu, Spanish interpreter for Mr. Chirino Diaz.
Would you raise your right hand for me? Do you swear or affirm that you will accurately translate between English and Spanish, Spanish and English, so that we can all discuss this file today?
I do, Your Honor.
All right, let Mr. Chirino know what we just said.
Buenos días, señor Chirinos. Estamos en la causa de la Fiscalía en su contra. Se acaba de presentar el fiscal James Memick.
Mr. Mena, what do we got?
Your Honor, I had an opportunity to speak with Mr. Chirino through the interpreter. He's going to plead guilty under 771 for 3 months, Your Honor, to abandon personal property.
Y sí, dígame, señor fiscal, qué es lo que vamos a hacer el día de hoy. Dice el señor fiscal, juez, yo tuve la oportunidad de hablar con el señor Chirino. Él se va a declarar culpable a dejar abandonar su propiedad personal bajo el código 771.43.
Mr. Chirino, do you understand your rights and options?
Señor Chirino, ¿usted entiende sus derechos y sus opciones?
Sí, yes.
Yes.
Do you understand the possible penalty for today's charge?
¿Y usted entiende las posibles sanciones por la acusación del día de hoy?
Yes.
Understanding all of that, are you pleading guilty today freely and voluntarily?
Y después de haber entendido todo eso, ¿usted se quiere declarar culpable de una manera libre y voluntaria?
Yes.
Mr. Mena, you'll have to explain to me how this works.
Señor Mena, por favor, explíqueme qué es lo que vamos a hacer específicamente.
I'm not sure, Your Honor. He left personal property airport in violation of the airport ordinance.
Yeah, so how does leaving his phone somewhere help him out? I don't understand that.
He did it intentionally, Your Honor. What it does is it keeps him in the Uber queue. So the phones are geolocated. So
Yeah. That's what I thought. Okay. All right.
Sí, a ver, explíqueme. Bueno, dice el fiscal, lo que pasa es que él dejó su propiedad en quebranto de las leyes del aeropuerto. Él básicamente dejó sus teléfonos para mantenerlo en la línea de una manera intencional. Dice el juez, muy bien, entiendo.
All right, Mr. Chirino, on September 17, 2025 at Detroit Metro Airport, did you leave personal property unattended?
A ver, señor Chirino, dígame, el 17 de septiembre del año 2025, ¿usted dejó propiedad personal abandonada en el aeropuerto de Detroit?
Sí.
Yes.
Mr. Mena, are you satisfied?
I am, Your Honor.
Señor Mena, ¿se adhiere a esto? Dice el fiscal Mena, sí, su señoría.
All right, Mr. Chirino, I have accepted your plea. Anything you want me to consider before I sentence you?
Bueno, señor Chirino, yo voy a aceptar su declaración de culpable. ¿Hay algo que usted me quiera decir antes de que yo le diga su condena?
Bueno. No
No.
fue algo que quise hacerlo intencionalmente, porque fue algo por una necesidad que lo hice, pero bueno, sí acepto que tengo la culpa de haberlo dejado.
I was guilty, I did it as a necessity, but I agree, I am guilty.
All right. I will delay sentence for 3 months. During that time period, stay out of trouble, no new charges.
Voy a poner su condena en suspenso por 3 meses. En esos 3 meses, por favor, no se meta en problemas. No quiero que lo acusen de nada más. ¿Está bien?
Muchas gracias.
Thank you so much.
Court costs are assessed in the amount of $300.
But you sent him down already. You already signed the waiver paperwork. Did you not want him to?
Thank you.
Today.
¿Eso lo puede pagar usted el día de hoy?
¿Pudiera pagarlo el próximo lunes?
Can I pay it by next Monday?
Yeah, say Monday, a week from today, 3 p.m.
Sí, una semana desde el día de hoy hasta las 3 de la tarde.
Ok, muchas gracias.
Okay, thank you so much.
You're welcome. Any questions?
De nada, ¿alguna pregunta?
En 3 meses tengo que volver, después, ¿qué tengo que hacer?
Do I have to come back in 3 months?
No, just stay out of trouble and it goes away.
No, simplemente no se mete en problemas y eso se desaparece solo.
Ok, muchas gracias.
Okay, thank you so much.
All right. Thank you, Madam Interpreter.
Thank you, Judge.
Thank
you.
Mr. Mena, who's next?
Luke Markle, Your Honor,
Markle,
with an M, yep.
appearances, please.
James Mena for the airport, Your Honor.
Luke Markell here.
All right, Mr. Markell, are you going
Yes,
forward
sir.
today without benefit of a court-appointed attorney?
Yes, sir, Your Honor.
All right, you met with Mr. Mena?
Yes, sir, Your Honor.
What did we come up with, Mr. Mena?
Your Honor, it's checkpoint violation. It's a firearm. He's going to plead guilty under 771 for 3 months. At the completion of the 3-month period, he can contact the airport police and get his firearm back.
Thank you. Mr. Markel, do you understand your rights and the options those rights present to you?
I do, Your Honor.
You understand the possible penalty for today's charge?
I do, Your Honor. Yes, sir.
Understanding all of that, are you pleading guilty to the charge freely and voluntarily today?
Yes, sir, I am, Your Honor.
Mr. Markel, on October 24, were you at Detroit Metro Airport?
Yes, sir, Your Honor.
And did you find yourself at a checkpoint?
I did, Your Honor.
Did you have a weapon in your possession at that checkpoint that you were not authorized to have there?
I did, Your Honor.
And that was a firearm?
Yes, sir, Your Honor.
Satisfied, Mr. Meno?
Yes, Your Honor.
So am I. Mr. Markel, excuse
Yes,
me. Any prior criminal history?
I do, Your Honor.
Pardon me?
Yeah, yes, sir, Your Honor.
Hold on a minute. I got somebody talking I don't need to hear. All right, when was your last criminal conviction?
Upwards of 10 years ago, I do believe, sir.
Okay. And are you working?
Yes, sir, Your Honor.
Where do you work? How long have you been employed there?
6 years in January. I own Wholesome CBD and supplements. A family-owned and operated business. I'm full-time there.
All right. And your CPL holder?
Yes, sir, I am.
All right. Anything else you want me to consider before I set the terms of sentence?
Yes, sir. I'm also a coach in jiu-jitsu, and I do my best to help people. I'm a member of church, and I'm very sorry for taking up the taxpayers' dollars and slowing up the line that day. And absolutely, it'll never happen again, sir. Absolutely not.
Yeah, it's usually quite an eye opener for people to get caught.
Yeah, I'm sitting there looking at the screen, and I'm like, oh well, there's the holdup, and I'm like, oh my goodness, and I told the TSA person right away, that's my revolver. It's loaded. I'm so sorry. It's on the third pocket in. I travel for work. And do events. Sometimes I'll have a couple of $1,000s on me, and so it's safe for me to have that. And that event that weekend, I didn't get home until about midnight on Sunday, and I normally take it, put it right in the safe. And Your Honor, I don't know. I had a crazy week that week. 6 a.m. training, and then straight to work, and then training after. It's 6 a.m. to 10 p.m. is what my schedule is currently for a big tournament that's coming up. And that Tuesday and then the Wednesday, it was church, and then we were actually on the cleaning schedule. So I didn't get home until it was like 11:30, 11, right around there when I got home. And then Thursday back at it. And then Friday morning, I packed my backpack, just running low on sleep, and it was an absolute, I'm so sorry. So sorry.
All right, I'll accept your apology. It happens a lot more than people realize. So for 3 months, stay out of trouble, no new
Yes,
criminal
sir.
offenses. Your court costs are assessed amount of $500. Can you pay that online today?
Yes, sir. I will. Yes, sir.
All right, go to our website, follow the prompts. Enjoy your day.
Thank you, Your Honor. Thank you, sir. Prosecutor, sir.
Good luck, sir.
Thank you.
That's all I have for now, Judge. I'm going to go into my break.
All right, you know where to find us.
Have a good
Camera's out, Judge. I think he has a couple.
Mr. Jadala, what do you got?
Your Honor, we're ready on Atwell and Pace.
Atwell and Pace, P-A-S-C-E?
PACE, correct.
Thank you. Let's start with Atwell.
Your Honor, respectfully, Sam Rajadala, P62186, appearing on behalf of Mr. Atwell. Your Honor, for purposes of arraignment, we'd waive formal reading and stand mute. purposes of pretrial, Mr. Atwell would like to avail himself to the plea whereby he'd be pleading guilty to the checkpoint violation and will be taken under advisement under 771.1 for a period of 3 months, Your Honor.
All right, Mr. Atwell, can you hear me?
Yes, Your Honor, I can.
Did you discuss your rights and options with Mr. Jadala today?
I did.
Understood those rights and the options presented?
Yes, Your Honor, I do.
And sir, do you understand the possible penalty for the charge?
Yes, I do.
Understanding all of this, are you pleading guilty to that charge today freely and voluntarily?
Yes, Your Honor, I am.
All right, Mr. Atwell, on November 10, 2025, did you find yourself at a checkpoint at Detroit Metro Airport?
Yes, I did.
At that time, did you have something in your possession that you did not have authorization to have there?
Yes, Your Honor.
And what was that, sir?
It was my former off-duty Glock pistol.
All right. Satisfied, Mr. Jadala?
I'm satisfied, Your Honor.
This was a 3-month?
3 months, 771.1. Correct, Your Honor.
Thank you. What should I know about Mr. Atwell before I sentence?
Your Honor, this was just a slip of the mind. He's a retired DEA agent, Your Honor. He understands he made a mistake. It was an accident. It's not going to happen again.
And the embarrassment alone didn't kill you, Mr. Atwell.
It came close.
I bet it did. I bet it did. Yeah. All right. Anything you want to add to that?
No, Your Honor. It's just it was a complete oversight. I was not planning on flying that day. My wife and I drove from North Carolina because we bought a house for our handicapped daughter in Jackson, and I had to run home. There was an emergency. My wife made a plane reservation at 6:30 in the morning. I get the next plane out. I grabbed my bag. I thought it had 2 sandwiches and a book in it, and I'd forgotten that I must have left it in the backpack. I had locked it in the glove box of my truck. But I driving around Detroit and Jackson, I didn't know if that was a good idea. So I vaguely remember throwing it in my backpack and leaving it in the house where I would have left it. But with all the stress and stuff going on, I just grabbed my bag and ran.
Yep. Yep. All right. Anything else I should consider, sir?
No, Your Honor, no.
All right. I'll delay sentence for 3 months. During that time period, you stay out of trouble, no new charges. Court costs are assessed the amount of $500. Can you pay that online today?
Yes, sir, I can.
Any questions for Mr. Jadal before I end the meeting?
How do I go about paying that?
If you just Google, internet search our court, 34th District Court, Romulus, Michigan, follow the prompts, and you'll have the payment options.
Okay. Well, thank you.
Good luck.
Thank you, sir.
Absolutely.
Airport day in Judge Oakley's court. Very interesting. Not something we see every day.
Good morning. Are you Adrian Hayward Jr.? And Mr. Parker, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Hayward, in cause number 24 DCCR 2149, you're charged with the 3rd-degree felony offense of assault family violence by impeding breath or circulation from May 23rd of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? Yes. And are you pleading guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Hayward is not competent? No. All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Mr. Nichols?
This is his first case that I'm showing, Your Honor. If he's going to be released on bond, Before sentencing, I'd ask, obviously, that no contact with victim, he stay away from that address, that he not be allowed to possess a firearm. While the allegation isn't for using a firearm, there's allegation in the reports that he had brandished one that evening.
Okay. What's your relationship with Rihanna McClain? It was your what? Your ex-girlfriend's cousin. So there's no reason for you to be around her, or it sounds like your ex-girlfriend at all, or anybody like that, right? So here's what I'm going to do. Based on the nature of your plea agreement, I'm going to reduce your bond in your case to $1,000. Condition of that bond, if you make it, is that you are to have absolutely no contact or no communication in any way. That's obviously in person, but it's through social media or sending messages or anything with her. Do you understand? You can't go to an address where she is. If you're somewhere and she shows up, you have to leave. Do you understand? And then also, as a condition of your bond, you are not allowed to have any firearms at all. So if you own firearms, you need to get rid of them. If you have a family member that can take them, I don't care what you do with them, you can't have them or have them in your home or your car, okay? Any questions? All right, we'll see you back at sentencing.
Thank you, Your Honor.
Thank you. And then Jason Jones. Okay. Mr. Rojas, you have Jalen Hendricks sentencing.
Hey, Sharon, he's on the other end.
That's sentencing. Good morning. How are you?
Good, how are you?
Good.
This is for my other one. He just gave me that this morning.
This is for which one?
Mr. Yeoman. Yeah, there's another question.
Okay. Morning, Mr. Coleman. Would you put that with Leonard Yeoman sentencing, please? I know. My nose is going to start.
All right, friends, while they wait for the next contestant, let's just step across the hallway and say good morning to Judge Stevens.
So needed. You keep your eye on your dad on the desserts. I do. Okay. You gotta keep him honest. How's that working? It's harder than I say. Good days, bad days. Yes, sir. Okay. On Mr. Birdsong and all jocularity aside, this is serious. You're charged with the first degree felony of murder. And what are we doing today?
Dan asked me to fill in for him. He's been important Jasper. Yes, and he just wanted to see if we could get a reset since he was tied up there.
Is there any, the state wants to be heard on this? Anybody from the state at all on this murder case? There we go.
There's a murder case up there, Jeff?
Yeah, it's we have serious things.
It's on discovery.
I understand. In fact, I'm not showing. I don't know who the prosecutor is on.
That's because I'm flying under the radar on this one, Judge.
I'm looking every resetting, there is no name for a prosecutor. But anyway, you're here.
I'm in.
They're asking for additional time. This is a case that we're going on 2 years, right?
Yes, sir.
So
I think we're getting close to if the next setting, if we don't work this out, we need to set it for trial. We need to do it, get it done. So,
okay, resetting 5 weeks. Is that good? That puts you as in the first full week is in January.
yes, sir.
And that delivered, kind of a fish or cut bait time.
Yes, sir.
Because we're coming up on 2 years, and that's time for a decision one way or the other on what direction to head in.
I know we're waiting for a while for Mr. Walker to get a expert to look at things, and I think that's been accomplished. We just hadn't had a chance to go over and discuss what's been found and what we want to do. And that's partly because of schedule difficulties for both of us.
How old was the deceased at the time of death?
He was 70.
Okay. 5 weeks good?
Yes, sir.
Oh, let me talk to the lawyers for just a second.
Okay, he's muted now, but this is a somewhat interesting case. Victim was 70. It makes me wonder, obviously we don't know the facts, it makes you wonder if this was like the guy's father or something, perhaps taking care of him, and he's being accused of something. Obviously I'm speculating, I have no idea, but it kind of looks like it would line up like something like that. I'll keep an eye on this, but since they're muted, we'll step back across the hall again. Judge West has her next contestant.
You were previously here in cause numbers 23 DCCR 2323 and 25 DCCR 0574. Entered pleas of guilty in each of those cases to evading arrest or detention with a motor vehicle. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor. The state has, Judge.
Are there any additions or corrections?
Not from the defense. Not from the state, Judge.
Mr. Hendricks, do you have a driver's license? No. Okay, so I'll explain what I'm going to do in a second. So I'm going to find Mr. Hendricks in each of your cases that you entered your pleas of guilty freely and voluntarily. In cause number 23, DCCR 2323, I'm going to follow the agreement you made and sentence you in accordance with it to a term of 10 years in prison, but probate that. You'll be on probation for 10 years. You're ordered to pay a $500 fine and to serve 30 days in the county jail. You will get credit for that time since you've entered your plea. In cause number 25, DCCR 0574, also find that you entered your plea freely and voluntarily, find sufficient evidence to find you guilty, and at this time follow the agreement and find you guilty of evading arrest or detention with a motor vehicle. Sentence you in accordance with that agreement to a term of 10 years in prison, but probate that. You'll be on probation for 10 years. You're also ordered to pay a $500 fine to serve the 30 days in jail that you will get credit for, and follow all of the rules and conditions of probation. So the rules and conditions of probation are very important, because if you don't follow all of those rules, you're going to be right back in here looking at 10-year sentences. Do you understand? You've already agreed to 10 years. So part of your probation is going to be to get you the help that you need for whatever's going on. So you will be assessed for any type of mental health care, and you're ordered by me to follow any recommended treatment. That means medication, counseling, whatever it is. If they say you need it, I'm ordering you to do it. You understand? Also, you are not to drive any vehicle, period, ever, unless you have a driver's license. So you cannot drive. And then if you, and all the other regular conditions of probation, and the probation officer will go over that with you. If you do everything that you're supposed to on this probation, it's a great opportunity because you'll be able to serve that 10-year sentence while you're on probation instead of in prison. But again, if you violate any of the conditions of probation, you will be right back in here and you'll be looking at that 10-year sentence in each of those cases. You understand? I'm handing you in each of your cases the trial court certifications. It shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir. You can go back with the bailiff.
Thanks.
And then Lamone Yeoman, sentencing.
Yeoman?
Good morning, you're Lamone Yeoman Jr.
Good morning.
And Mr. Yeoman was previously in court on probation for aggravated assault with a deadly weapon and also burglary of a building, and pled true to allegations in the motion to revoke those probations to counts 1, 2, 4, and 5. Does the state have any evidence with regard to the others, or are you ready to go forward?
No, Your Honor, just ready to go forward.
And I've received and reviewed the updated pre-sentence report. Has everyone had an
I
opportunity?
misspoke, Judge, on the, because I believe you pled true, not true to number 7, which is failing to report. I do want to address those.
Okay.
I'm sorry, I meant that on number 6, the new firearm case, nothing's been brought over, nothing's been filed, so I have no evidence presented on that count.
Okay. Let me get that pulled up. You may proceed.
Would you please?
I'm sorry, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
It's Ms. Cole, right?
Yes.
And how long have you worked for probation?
A year.
And during your time of probation, have you supervised Lamone Yeoman Jr.?
Yes, sir.
And was he required to regularly report?
Yes, sir.
Were there times where he failed to regularly report?
He reported one time on April 7th, and we didn't see him again.
He reported on the 7th, you've not seen him since?
Until he was arrested, yes, sir.
So is it safe to say that on April 11th of 2025, April 21st of 2025, April 30th, 2025, May 9th, 2025, June 6th, 2025, and July 7th, 2025, he did not report as required to see you or to the probation office?
That is correct.
Thank you. I'll pass witness.
Any questions?
I'm sorry, can you give me that date that he did report again?
April 7th.
April 7th. And have you were able to talk to him about the different reasons why he didn't report?
I called him actually on his birthday, and I told him we have a warrant, and he told me because it was his birthday, he was not coming to tell him.
Are you aware of any time while he's, since his removal from safety, are you aware of any times where you may have called him or sent him text messages about a data report that he didn't get those messages?
I called, I sent letters, and I called his mother.
Okay.
And his mother told me that he was aware of the warrant.
I'll pass the witness.
Another question for purposes of proving up count number 7, Your Honor.
Okay. Based, any witnesses or information about count number 7?
Oh, yeah.
All right, then, based on that testimony, I am going to find sufficient evidence to find count 7 true. All right, and so, again, I've got the updated pre-sentence report as well as there was a letter provided this morning. Mr. Nichols, have you had an opportunity to review the letter, this? It's
I did
from,
not show it to Mr. Marcus.
and take a look at that. Have y'all both had an opportunity to review the pre-sentence report update?
We have, Your Honor. Yes, Your Honor, I have.
Any additions or corrections to that report?
Just a correction to the page 1, the bottom paragraph. It says that Mr. Yeoman was absconded from the aftercare program. He tells me he did not abscond. He was kicked out of that program.
Okay. I guess being kicked out's better than being absconded. Anyway, all right. Anything else?
That's the PSI note.
And it looks like there was cap of 8 years agreed in the aggravated assault case, and then just really open in that burglary of a building on the state jail to run concurrently, correct?
Yes, Your Honor.
Mr. Rojas, you may make argument.
Thank you, Judge. The court knows from reading the PSI, Mr. Yeoman was in Safe P. He did successfully finish the first part of Safe P. The aftercare program is a part that he was kicked out of. He pled not true to count 1 as far as, I believe that counts as he was selling K2. What Mr. Yeoman tells me is that one of his roommates in the aftercare was selling K2. All the roommates in that particular room were kicked out because the person selling did not claim ownership of the K2. So everybody in that room was kicked out. And that really just started the downfall for him on the probation judge, because at that point he was released from safety in Houston. He had to find transportation back to Port Arthur. He tells me the phone that he had, the phone number that the probation department had originally, he did not have that phone anymore. So when the messages were given to him to report, he wasn't able to because he didn't know about those. When he finally did get back to Port Arthur, he had trouble finding transportation. And that's when the new offenses came up in August, and as far as the possession and the weapon charge. So according to, if his story is to be believed, that he was not selling K2 and everybody in the room got kicked out.
There's not much for you to argue here today, is there? You haven't given your attorney anything to argue for you.
I don't want to say that it's not his fault, but really, if he truly was not selling the K2, he would still have been able to finish that safety program. And that's what he's asking to give the opportunity to do this morning, is finish that aftercare program, possibly even due to those new offenses, one of them being weapon, maybe even consider sending him to ISF Cognitive to help him make better decisions. And if you had more questions about what happened at Safe P, Mr. Young is willing to talk about those.
So there was an ISF, okay, there have been 7 administrative hearings, 7. There have been, on the first case, the aggravated assault case, this is the 3rd motion to revoke probation. The first motion was filed literally, what appears to be a week or 2 after got on probation, given another opportunity. Then, did he go to ISF? I can't tell. Anyway, regardless. Then we get a new case of, while you're on probation for aggravated assault with a deadly weapon, you obviously aren't doing what you're supposed to. You get some jail sanction where you spend 5 weekends in jail. Then you decide to go commit another felony of burglary of a building. You come back in here. We all agree somehow for you to stay on probation for the first felony, give you another probation for the second. And then we're here again. I sent you to Safe P. And not only did you get kicked out of Safe P, whether it was your fault or not, you also have been arrested now for 3 new offenses. Is that right? 3? 2. 2. Sorry, 2 new offenses. Mr. Nichols?
Judge, I'd urge the full extent of the cap that was agreed upon. Even without the problems in safety, the fact that he simply has not participated in his probation for the last several months or most of the last year, that he's been given multiple chances. And if you go back to his original PSI from 2019, from the 2019 offense, the Agasol, he downplays what he did. And he's never taken responsibility really for what he does. And I think the recommendations of the probation are correct in that he just refuses to grow up, refuses to take responsibility for his actions. So I think the 8 years is appropriate, Your Honor.
I think you're lucky that Mr. Rojas got you a cap of 8 years, honestly. Because what you're on probation for is a second-degree felony, the first one. And the opportunity after opportunity after opportunity that I've given you and probation have given you, at some point we kind of start taking it personal that you're just saying, screw y'all, I don't have to do anything. She's gonna keep giving me probation. I'm gonna come in, I'm gonna write a nice note, take responsibility at the last minute. You've done none of that. You've done nothing that you're supposed to. You make me look like an idiot up here for giving you all of those chances. I'm going to find in cause number 19-32846 that you entered your pleas of true to counts 1, 2, 4, and 5 freely and voluntarily. Find those counts true. Also find count 7 true. Find sufficient evidence to find you guilty, and at this time find you guilty of, which one is that? Aggravated assault with a deadly weapon. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 23, DCCR 1556, also find counts 1, 2, 4, 5, that you entered those pleas of true freely and voluntarily. Find those counts true. Find count 7 true. Find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a building. Sentence you in accordance with your that agreement to a term of 2 years in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In each of these cases, they'll run concurrently, which means together at the same time. I'm handing you the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of those judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. You can go back with the paper.
Thank you, Your Honor.
Thank you.
And again, I apologize. People will watch me blow my nose all day, but eventually I should live through this. All right, this is a formal hearing in the matter of Jasmine Ray Adair. The charge alleges a violation of MCL 257643 under the Motor Vehicle Code for following too closely. As I indicated, this is a civil infraction. I believe it carries 2 points, and it does carry, I believe, $120 fine. Assistant Prosecuting Attorney Abigail Stoll is here with her Officer Jesse Raymond. The jurat is signed. We're ready to proceed. Madam Prosecutor.
I'll waive opening argument.
Okay, certainly. We don't need any. Are you ready to proceed?
Yes, Your Honor.
Okay. You may call your witness.
I'll call Deputy Raymond to the stand.
Good morning, sir. Do you swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief? I do. Thank you. Have a seat. And would you state your name for the record, please?
Deputy Jesse Raymond.
And spell your first and last name?
JESSERAYMOND.
All right, Ms. Stoll.
Deputy Raymond, where are you employed?
St. Joseph County Sheriff's Office.
How long have you worked there?
Just under 6 years.
What do you do?
Primarily primarily now I'm covering complaint vehicle, meaning I take complaints on the road. I also conduct traffic stops.
Do you have any other experience in law enforcement?
Outside of the sheriff's office, no, but I do have other assignments.
Laura, can I get a white pen?
Were you on patrol on July 25th of 2025?
Yes, sir.
What shift?
I was on the day shift. I was assigned to the traffic unit.
What was the general location where you were at?
I was traveling southbound on 131. I was south of Three Rivers. I was just approaching Drummond Road.
All right, did you see something that caught your attention?
There's moderate traffic that day. I did notice two vehicles that were very close together.
Could you describe the vehicle that was following?
I don't recall.
What did you do after that?
So I had my radar unit activated. I clocked the lead vehicle going approximately 60 miles an hour. I saw the following vehicle was traveling quite close as they passed by. I estimated it to be about a car length behind. I turned around at that intersection and it took me about a half mile to catch up. I caught up to him just before Gleason Road where I conducted the traffic stop.
I'm sorry, forgive me, I'm a little hard of hearing. I didn't catch the tail end of what the witness just stated.
You caught up half a mile at Gleason Road and then you said something else.
That's where I conducted the traffic stop. It was
Okay.
just south of Gleason, northbound.
Thank you.
And then what did you do after that?
I made contact with Miss Adair. I explained the reason for the traffic stop. Got her license, registration, insurance, and issued a citation.
Is Miss Adair in the courtroom?
Yes, she is.
Could you describe something she's wearing and point her out, please?
She's wearing gold frame glasses and a black shirt.
Let the record reflect that the officers identified the defendant.
It may.
And then did you write Miss Adair a ticket?
Yes, I did.
What for?
For following too closely.
In your experience, was that a reasonable length to keep?
No, I have considerable experience, particularly with traffic crashes where there's rear end collisions. Almost all of those cases, it's a matter of either following too closely or they're unable to stop in a short period of distance.
Objection. I don't think there's a foundation laid for his expertise as being an expert with traffic crashes.
Well, all right, we can establish that. He indicated he'd been an officer 6 years and then traffic enforcement. Madam Prosecutor, would you inquire further about his qualifications in this area?
Deputy Raymond, do you have any sort of special training or experience in traffic accidents?
Just academy training and then routine experience with traffic crashes. I respond to and investigate crashes as a traffic unit, also as a complaint deputy.
How often do you respond to these accidents and complaints?
I would say on a weekly basis over the last 5.5 years.
How many citations do you think you've actually written?
I couldn't give you a number.
Over hundreds? This is a civil infraction and he's given his opinion regarding this circumstance. I think he's qualified in the context of a traffic enforcement officer, certainly not an accident reconstructionist or anything, but I'll allow the testimony regarding his opinion about why he wrote this citation.
Thank you, Judge.
You said that you were traveling on US 31 southbound.
Objection asked and answered.
We're just getting back into it. Yeah, it's 131. Go ahead.
Where were you located when you stopped the defendant?
We were on US 131 traveling northbound. We were just south of Leeson Road.
In what township?
That's Fabius Township.
In St. Joseph County, Michigan?
Correct.
Thank you. Nothing further.
Morning, Deputy. I'm going to ask you some questions. If anytime during me asking the questions, if you don't understand or it's not clear, feel free to ask me to clarify. Deputy, you testified that you were the one who stopped my client, Miss Adair, correct?
Yes.
Okay, so you recognized her?
Yes.
Okay, but didn't you just testify you didn't know what kind of car she was driving?
Correct.
Okay, would it help if I showed you the ticket to refresh your recollection?
Yes.
Okay, may I approach, Judge?
Yes.
Or I guess the jurat? Let me know when you're done looking at the ticket. Is your memory refreshed?
I have the citation for a 2012 Toyota. I don't remember the model of the vehicle. I do remember the Indiana registration.
Would you disagree with me if I told you it was a Toyota Prius?
No.
Okay. So when you testified for the people, you stated that you were going in the opposite direction, right?
Correct.
And you just testified that my client was driving a Toyota. Do you know what the vehicle was that was in front of her?
I don't recall.
Okay. Would you have any reason to doubt me if I said it was a GMC pickup?
No.
Okay, but you did catch the distance between that vehicle and my client.
Correct.
Okay, and you remember that there was one car length.
Correct.
Okay. Did you provide any video recordings to the people? Like body wear cam or dash cam?
I did not. I don't know if my clerks did or not.
Okay, so would it surprise you if it was provided? Okay, and do you recall what you said to Miss Adair when you approached her vehicle?
Yes, I do.
Can you share with me what you said?
Yeah. So I asked her for her license, registration, and insurance, which she provided me. I informed her that she was following the vehicle in front of her too closely. I told her that they were traveling close to the speed limit. And given that speed, that was too close to be following the vehicle in front of her.
Would you doubt me if I just stated that you stated at the time that the courts have found that you need to be traveling one car length per 10 miles per hour?
I did say that to her, not as a.
What authority are you relying on for that statement? When I say authority, legal authority.
I was using it as an education piece.
So you just made it up?
No, I did not.
Okay, well, where'd you get it from?
I don't recall.
Okay. So you read this, you're familiar with the statute, right?
So
And what does it use?
you must be no closer than reasonable and prudent to the vehicle.
Reasonable, prudent person. Are you familiar with, you're familiar with the state of Michigan Secretary of State, right? Okay. Are you familiar with a publication that they put out called What Every Driver Must Know?
I'm familiar with it. I don't recall any text in it.
Would you doubt me if I said it doesn't say anything about a car length for every 10 miles? Okay, I'll help you. It doesn't.
Objection, Your Honor. Hearsay.
Well, the officer accepted the answer that he accepted that he is familiar with that publication, which every Michigan driver has to review before they take their driver test. I'll allow it. It's not damaging really either way.
As a matter of fact, well, let me back up. Would you doubt me if that publication takes into account what is considered the reasonable distance between two traveling vehicles? Okay, would you doubt me if it says that you need to take into account the vehicles, the drivers, condition of the road, weather conditions? Okay. You interestingly didn't testify to, you talked about moderate traffic, but do you remember the weather conditions that day?
Yep.
Okay, what were they?
It was a clear day, dry roadway.
There was no rain, was there? Mhm. Okay, and do you know that you recall on the side that my client was driving on, how many vehicles were traveling? About the time that you witnessed these two vehicles going down that road, I'm sorry.
Specific number, I don't recall.
If I played the video, would you doubt me that it was just that vehicle and her vehicle? Okay. As a matter of fact, on your side where you were traveling, where you said you witnessed the cars traveling too close to each other, there was a lot more traffic, or as you said, moderate traffic. Would you doubt me? Okay. Did you notice that, or do you strike that? When you came up behind my client, did you notice the, I guess, double lines, dotted lines in the roadway?
At the location of the traffic stop. I believe it would have been a double line, but I don't recall.
You don't know if my client was attempting to pass that vehicle either, do you? You didn't ask her, did you?
I had turned around and followed the vehicle for approximately half a mile.
Okay.
Real quick while he's between questions, because I know you have to leave soon. Barbara, thank you for the 5 gifted memberships and the $5 super chat. I really appreciate you.
I'm gonna inject myself a little bit.
I'm sorry, Judge.
I'm gonna inject myself into this to add some context. On the map, run 131 looks like it runs flat, straight, north and south. Is that correct?
It's a relatively hilly section.
Well, that's what I'm gonna ask. It's actually on what's known as the Big Hill. Is that correct? 131 and Drummond Road is on what's known as the Big Hill between Three Rivers and Constantine. Is that correct?
I'm not familiar with the term.
You're not? Okay. Anyway, it's a big hill and it's common. Well, maybe I'm too old, but there have been many, many accidents there. One time we had 2 drunk drivers hit each other on the big hill and they were both killed. Anyway, was this on the hill?
A portion of the observation period was, yes.
Okay, so this is a big hill. And so they're both going up the hill at that point. Is that correct?
They had gone up the hill and I had stopped them after descending down.
Okay. All right, thanks.
Anything else, Judge? I'm sorry.
No, I don't know if you've been there, but
Unfortunately, I'm not familiar with.
At any rate, it's on the big hill, and apparently they were headed uphill, and then he stopped them as they headed down.
If I played the video of you turning around, well, is your video activated? It's not running all the time, right, Deputy?
It's running, but it only pre-records a certain time frame before it's activated.
Okay, because I was it was shared with me, the video, but it wasn't shared of, I guess, where you felt that the car lengths were too close, but I got a video that shows you stopping the vehicle. I don't know if it would help the court making a decision if the people don't object. I mean, I'll play the video.
Well, I was hopeful they would play it.
I'm kind of a little surprised, but they can present their case any way they want.
Yes. Yeah, you can present the video to the officer. We have a way to do it.
I'm not technical. I mean, I could set this up there and you can look at it.
Well, we have a way to play it on the big screen. Although I'm not sure any of us are technically adept enough to plug it in. It should plug in.
I'll give it a shot. Okay.
Well, let's undo the cord. See, it's Velcroed there to the wall. All right, you should be able to do it from your laptop at your Ms. Davis can do it. I don't know. Josh, have you done it from this?
I think I have a port for this, Judge. I think you might be. Forgive me for what you're about to witness on my desktop. That looks like madness, but there's a method to it. So if it. Is there something that needs to be?
Yes.
While they sort out the tech, I want to point out what Michael just put in the chat. This is one of those times where it's definitely the principle rather than the money. I would agree. This is a $150 ticket that they're fighting over here, ladies and gentlemen, and that's what I find intriguing about this. They're definitely trying to make a point. So let's see where this goes.
I don't know which, it's been so long since we've done this. It shouldn't be such a profound problem. I think it's this big.
And just so I'm making a record here, Your Honor, the video that I have that was shared with me just reflects the stop. I don't think it actually reflects what the deputy testified to what he witnessed when he was coming the other way. So I don't want you to go through all this laborious effort.
All right, so it doesn't show the actual.
It shows him doing a U-turn and coming up behind the two vehicles, my client being the closer one to him. It doesn't show what what Deputy
Raymond
James testified to what he witnessed when he was coming the other way. That's why I asked him about if his camera was activated at that time. If there is footage of that, it wasn't shared with me.
All right. Rather than get lost in the weeds here, we didn't prepare for this.
I'm sorry.
Just go ahead and show it the video from your laptop.
From the laptop. Okay. And prosecutor, do you want to stand in front of this so they can see it?
It's not ideal, but there's no jury. It's a formal hearing. Can you see it? Abigail, maybe you can stand behind it.
Let me make sure the volume's on.
What are we seeing here, officer?
So I believe at this time I had already turned around. I was traveling northbound.
Okay.
Like he said, you can't see in the video the time that they initially passed me due to the latency in the activation of my recording.
So you're going down the hill at this point. Is it alleged that she's following too closely at this point?
Yes.
Yes?
26, go ahead. Indiana commemorative Boy George, X-ray 233, BGX 233.
Traffic stop. Civil infraction. Traffic violation. US 131/Leeson RT Fabius Township.
So this, you can't, I don't believe you can hear anything. The body work camera, this is just a stop, Judge and Madam Prosecutor. If you want to hear the body wear camera about the car length thing. So this is the stop. This is the video of the body camera. Thank you.
75 traffic stop. Indiana commemorative Boy George, X-ray 233, BGX 233. Hello, how we doing? Wonderful. Do you have your license registration? Pardon the traffic. The reason I stopped you, you and the vehicle in front of you guys were both going about the speed limit. You were right on his tail, so you got to have a little bit of space off of him. Okay. For rule of thumb, there's not really any number on it specifically. The courts have found that about one car length for every 10 miles an hour. So you really should have been 5 or 6 car lengths back behind him at the least. So, okay. You got insurance on the vehicle?
Okay. Thank you for indulging me, Judge.
Thank you. That certainly didn't translate very well to live stream, but they could hear it and I could see the video. I didn't see what was going on the way up the hill, but I could see what was going on the way down the hill. All right. Any further questions for this officer?
No, thank you, though. Thank you, Deputy. Appreciate it.
Ms. Stoll, do you have any further questions for the officer? Do you have any questions for the officer?
No, Your Honor.
All right. Thank you. You can step down. Any further witnesses?
No.
All right. Mr. Spinolio, you have any, do you wish to call the defendant?
Judge, if you're prepared to make a decision, and being mindful of the court's docket, if you're prepared, I'll waive presenting my client. I mean, the video speaks for itself. I think that the facts, what the deputy said,
thank you. I'm disappointed in that. The prosecutor didn't play the video. Did you even viewed it? Have you seen it before?
I saw it, Your Honor.
Okay. Well, I would have liked to have seen it as part of the prosecution case because she's right on his tail. The video sunk your boat. You're doing pretty good because they hadn't even looked at the ticket or know what kind of vehicle it was, and his testimony was unclear, and it wasn't clear where it was. It's on the biggest hill in St. Joseph County. But you were right on his tail. I don't know where you were going up the hill, but going down the hill right up until the stop, you were right on his bumper. And it's not a place to pass. passing is prohibited there for quite some time, going up the hill and down the hill. What the statute actually says, the officer says, the rule of thumb is you should give 1 car length for every 10 miles an hour. That is a quote unquote rule of thumb. We've heard it on television commercials and other thing. It isn't in the statute anywhere. But what the statute says, the officer quoted it pretty well. The driver of vehicle shall not follow another vehicle more closely than is reasonable and prudent, having due regard for the speed of the vehicles and the traffic upon and the condition of the highway. So this is a 2-lane highway. It's a state highway with a center line on a large hill, and passing is prohibited going up the hill and down the hill. The speed limit there is 55. He testified that he thought the first car, which he couldn't remember what it was, if he looked at the video, maybe he could have discerned it, was going 60. The ticket says she was following lead vehicle, 1 car length, going 57 miles per hour. This is a civil infraction. You can't go to jail for a civil infraction. And you don't have the right to proof beyond a reasonable doubt. You have a right to proof beyond a preponderance of the evidence, which is a much easier standard for the prosecutor to meet. It means just barely more than the other side. So I was trying to figure this out, but as soon as I saw the video, in my impression, you were too close behind that truck. So I find that you're responsible for following too closely. And I'm gonna fine you $120. You can pay that today, or I'll give you 30 days to pay it if you need it. Or do you want to pay it today, or you want me to give you an envelope to pay it? All right. We don't have enough trials for young officers to learn that they're going to be subjected to cross-examination. And when a competent attorney comes in and asks questions and makes appropriate objections, it's a lot harder than some layperson trying to do the best they can. So the point being, when you come to court, you should review your police report, you should review the ticket, you should review the video. The video should have been presented, but I'm not doing your case. The defendant actually provided it, which gave the court proof beyond a preponderance that she violated the statute, but you can't sleepwalk through these. This defendant came prepared, but I did find a violation. So you can go out to the counter, pay the $120. This will go on your Michigan and eventually Indiana driving record. It's not exactly the crime of the century, but you were too close to the car ahead of you, in my view, after watching the video.
Perfect. We have one person that has friends or family here. So we'll call that case first. That is Samantha Yale. Miss Yale, good morning. Miss Yale, your mother, along with her friend Miss Collette, are both in the courtroom, ma'am. You're here because you've been accused of 1 count of first-degree misdemeanor theft, 4 counts of second-degree misdemeanor theft. These are all retail theft, and 1 count of scheme to defraud. That last charge is a felony charge, Miss Yale. There is probable cause for all 6 charges, ma'am. Miss Yale, your pretrial release sheet from the jail says that you're not on probation. Is that correct, ma'am?
Yes, sir, I'm not.
So how long have you been off of your federal probation?
A few months.
And you have no charges pending anywhere, correct?
No, sir.
Okay, that's good. That means you're going to be entitled to a bond unless there's something else I don't know. I'm going to listen to the attorneys and I'll be glad to set your bond in this case. Mr. McDaniel, anything on behalf of Michelle?
Your Honor, we just asked for a reasonable bond and, hopefully her mother, I don't know if her mother maybe wants to pay a cash bond, but just some kind of reasonable bond, maybe she get out and try to take care of this.
All right, Mr. Mitchell.
If she wants to do a cash bond, we have no objection to that, but obviously we ask for no contact with Walmart.
Okay. Thank you both. Michelle, I'm going to set your bond at $2,500 each on your 5 misdemeanors, $5,000 on the felony. Those are pretty standard bonds, especially for someone that has a criminal history. You may have even been on federal probation when these charges allegedly occurred. They supposedly occurred in July and August of this year. So I'm talking to your mom now. I don't know when she got probation, but these charges allegedly occurred late July and early and mid-August of 2025. Supposedly they're on video. So we'll see what happens when she comes to court. So your bond is $17,500. Now, if you prefer a cash bond, the state has said they have no objection to that. The advantage to a cash bond is if you post the cash bond, let me back up. If you go through a bondsman and you give them 10%, it was just kind of a normal charge. They negotiate, but that's kind of a norm. 10% would be $1,750. You won't get that back. It's gone. It's spent. If there's restitution allegedly owed, and if the state and defense agree, a lot of times I'll set a cash bond. So it's the same amount, $1,750. The difference is it's held by the clerk of court until we see how the case is resolved. Now, there's a statute that says if there's a cash bond, if there's a bond posted, that money has to be applied towards court costs and fines if there's court costs and fines or restitution ordered. So you still may not get it back. The difference is if I set a cash bond and the case is dismissed, you would get it back. Whereas if you pay a bondsman and it's dismissed, you still don't get it. So a cash bond, you can't, that's one disadvantage to a cash bond, and that's an advantage to a bondsman. So a bondsman may say, it's 10%, we're going to charge you 10%, but only 5% up front, and you can make payments on the other 5%. If you do a cash bond, it's that amount. There's no, the cash bond would be the equivalent of what you paid the bondsman. It'd be the 10%. So it's $1,750 cash. Or if you go through a bondsman, it's $17,500, and they may charge you $1,750. But if a bondsman very well may, I've heard of people say that bondsmen will take not all 10% up front. They may take 5% up front and let you pay the other 5% in payments. So if you, it's just a personal preference. The bondsman gets a fee for their services if you use them. If you don't use a bondsman, then they're not involved. Any preference on that? Michelle, your mother's thinking about the bondsman. Do you have anything you want to say?
Yes, Emmanuel, tell her Emmanuel. Peggy knows that's who we went through before with Jonathan.
So her bond is $17,500 cash or surety, and she has a condition to have no contact with any Walmart while this case is pending. You can't go to any Walmart at all while this case is pending, Michelle.
Yes.
I'm going to ask the
Yes,
jail
sir.
to give you a notice for your court date. It should be January the 6th at 8:30 a.m. should be your court date in the circuit court. Do you have any questions, Michelle?
No, sir.
In the courtroom, ma'am, do you have any questions?
What is Emmanuel's last name?
It's called Emmanuel Bail Bonds. I've just heard of Emmanuel Bail Bonds. That's what's got to be. That's what you're talking about, right, Michelle?
Yes, sir.
Emmanuel Bail Bonds.
I'm just fixing to have open heart surgery, and I think it's scheduled for the first of the year, so it's kind of like, I don't know, for some reason that comes up the same court date is, can it be rescheduled or something?
That's up to Judge Garcia, ma'am. And Judge Garcia is going to want, so if you get some medical documentation, if you have open heart surgery the same day as her court date, Judge Garcia, typically most judges are going to say they'll grant her a continuance to the next month, but I can't speak for her. She's going to want some medical documentation. At least I would want some medical documentation. She probably will also. You also may want to wait and see the videos before you decide if you're going to post bond or not, because if she really did these things on video, then that may be a factor for you to take into account whether you spend money posting bond for. You'd have to wait till she got an attorney appointed. Then when she gets an attorney appointed, the attorney can get the video. She's entitled to see them.
Oh, okay.
Okay. Have a good day. Thank you for coming. We have Rhonda Weeks. Ms. Weeks, good morning. Ms. Weeks, you're here because you've been accused of one kind of petty theft. Ms. Weeks, this is listed as a failure to appear, but I believe I saw in the court file where the notice came back. So I don't know that it's a genuine failure to appear. I don't know that you got your notice, but Ms. Weeks, there clearly is probable cause for the charge. Supposedly, this was captured on video. I'm going to appoint the public defender's officer to represent you, Ms. Weeks. I'm going to ask that you listen to Mr. McDaniel, your attorney. Your Honor, I spoke with Ms. Weeks. She's going to plea of no contest. She signed a plea waiver form waiving right to a jury trial and call witnesses. The understanding should be sentenced to 6 months probation, $370 fine, restitution to $51.75, no contact with the homeowner or the home in question in the complaint, and that'll resolve this case today. Thank you, Mr. McDaniel. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Ms. Weeks, did you hear that agreement?
I did.
Ms. Weeks, do you have any questions about that agreement?
No.
And ma'am, is that the plea that you would like to enter?
Yes.
Ms. Weeks, I'm going to accept your plea of no contest to the charge of petty theft, ma'am. Withhold adjudication of guilt, place you on probation for 6 months, ma'am. Sentence you to $370 court costs and fines. $51.75. That's not what's in the complaint, is it?
There's an invoice that was sent in later on that shows it being $51.75.
Okay.
So that's the official amount.
All right, thank you. So $51.75 restitution. The clerk's office is by statute can charge $3.50 clerk's fee per payment. So if you pay it all at one time, it'll only be one $3.50 payment fee. Ma'am, Miss Weeks, try to get everything done early so you can get off early. You've got to do half your probation. Everybody does, but at the halfway point, you will be possibly may get off early. Miss Weeks, what's going to happen next, ma'am, is they're going to let you use the phone to call friends or family for transportation. Then they're going to bring you to the courthouse after you get back, rest back in your regular clothes. When you get to the courthouse, you'll meet with Mr. Goodson or Mr. Ham with the probation office. And once they explain everything to you and give you a chance to ask questions, Miss Weeks, you'll then be free to go. If you do call friends or family, you can tell them that you can be picked up in 30 to 45 minutes at the Jackson County Probation Office here at the courthouse. Ms. Weeks, do you have any questions?
No, sir.
Mr. Goodson, anything else?
Just for clarification, the victim's name is Christopher Scott Lyles. According to Mr. Mitchell, he got an address in Sneeze, and then he got an address in Naples. So I don't know what. Just for clarification for, I
He
guess.
may have moved to Naples.
I think the state attorney's office will have to get you an address. I don't know. I'll order it payable to him, that amount, but it's their job to get you the address and send it to you.
So no contact with him or any residents.
Yeah, no contact with that. No contact with that individual for sure. Okay. I'm not keeping you away from the apartment complex, especially if he's no longer there, but no contact with him at all. Ms. Williams, something else? It's not a retail theft. So since it's not a retail theft, I'm assuming there's not going to be a retail theft program. Is that accurate, Mr. Mitchell?
We're not requesting one.
Ms. Weeks, any questions, ma'am?
No, sir.
All right, man. Wish you the best. We have Gary Wilson next. Mr. Wilson, good morning. Mr. Wilson, you're here because you've been accused of violating the terms of your state probation. The warrant that I've got a copy of is signed by the circuit judge, Judge Garcia, and it has no bond. Mr. Wilson, I'm going to arraign you this morning. We do that at first appearance if there's an affidavit filed by the probation officer because we want to get you a lawyer appointed if you want one. Mr. Wilson, would you like to have an attorney appointed to represent you?
Yes, sir.
I'm going to appoint the public defender's office of the 14th Circuit to represent you. Listen to Mr. McDaniel, please.
Your Honor, we're going to plea of not guilty as to sentence on January 8th, and I advise you, Mr. Green, come by and talk to him prior to that hearing.
Thank you. Mr. Mitchell, anything in that case?
No, Your Honor.
So, Mr. Wilson, Mr. Green will see you before your court date. Any questions?
No, sir.
Have a good day, sir.
I'll be here at Livingston.
Next case we have is Destiny Brodnax.
I'll do her last.
Okay, that brings us to Jack Xavier Livingston. Mr. Livingston, good morning. Mr. Livingston, you've been here because you've been accused of one count of grand theft of a firearm and one count of possession of firearm by a juvenile delinquent. Mr. Livingston, looks like they bumped this up to adult court. When I say they, I mean the state attorney's office has charged you as an adult. Mr. Livingston, there is probable cause in the complaint, and I want to listen to the attorneys before I set your bond, sir. Mr. McDaniel, anything on behalf of Mr. Livingston?
We just asked for a reasonable bond.
Mr. Mitchell?
We're okay with a reasonable bond and the condition of no firearms.
Mr. Livingston, I'm going to set your bond on the third degree felony grand theft at $5,000, on the possession of firearm at $10,000. Mr. Livingston, your total bond is $15,000 cash or surety. You do have a condition not to possess any firearm while the case is pending. You also have a condition to have no contact with the alleged victim. Mr. Livingston, you'll get to use the phone in a few minutes, sir, to try to post a bond. Do you have any questions?
No, sir.
All right, Mr. Livingston, wish you the best. So that was 15,000 total.
It's the Courtroom Files Live. It's Thursday. Welcome. Good morning. Michael Groff filling in for Dan Soul. And he'll be back tomorrow. Don't worry about that. But in the meantime, we're just hanging out here and watching some first appearances with Wade Mercer in Florida.
Your attorney, Mr. McDaniel.
Your Honor, I spoke to Ms. Broadnex in 24415 MM. We're going to enter a plea of no contest to the charges listed. She has signed a plea waiver form, waiving the right to a jury trial and call witnesses.
So it's a straight up plea?
Yes, Your Honor.
Ms. Broadnex, let me get you to raise your right hand. Ma'am, do you solemnly swear or affirm the testimony you're about to give in this case to be the truth, the whole truth, and nothing but truth, so help you God?
Yes, sir.
Okay, so Ms. Broadnex, you're here on this charge that you're aware of, ma'am, accused of one count of petty theft. Ms. Broadnex, I've read the complaint, so I'm familiar with what the allegations are. You need to understand you have the right to a jury trial or a trial. In most cases, the right to a jury trial, but you've certainly got a right to a trial either in front of a judge or jury. If you exercise that right, you get appointed attorney, probably be Mr. McDaniel, someone with the public defender's office, and then you would get a chance to call and cross-examine witnesses at that trial. Do you understand that, ma'am?
I do.
You have the right to the trial and you have those other rights I just mentioned. Do you understand those rights?
Yes, sir.
But if you enter this plea, you're waiving those rights. There will not be a trial. You don't get to call witnesses. You don't get to cross-examine witnesses. I will listen to you. I'll listen to Mr. McDaniel. I'll listen to Mr. Mitchell with the state, and I'll decide what sentence to impose today, and there won't be a trial. You'll be waiving those rights. Do you understand that?
Yes, sir.
Do you also understand the maximum penalty for this charge is 60 days in the county jail? That's the maximum I can sentence you to. Do you understand that?
Yes, sir.
Okay. Do you have any questions you want to ask me before you enter that plea?
No.
Questions?
No, I do not.
So
No,
the
I
plea
have
Mr. McDaniels wants to enter, that's put on the record, a plea of no contest, knowing everything I've told you. Is that the plea you would like to enter?
Yes, sir.
Okay, so I'm going to accept your plea of no contest to the charge of petty theft with the advice of counsel. Now I'm ready to proceed to sentencing. So Ms. Broadnex, anything you want to tell me you think I need to know about the case, I'm glad to listen, or Mr. McDaniel.
Judge, I spoke with Mr. Broadnex and I, looked up her history and whatnot. She did turn herself in. She come back, turned herself in. Her mother lives in Greenwood and she's living there at her mother's house. Her only history she has, I think, is maybe a disorderly conduct or something from another state some time ago. We just asked the court to take those things in consideration, and Ms. Broadnex is going to make a statement.
Your Honor, at the time of my arrest last year and a half ago, I was under the influence of drugs and alcohol, and I was also in a very abusive relationship and homeless. So then, like, his best idea for me was to just leave the state and flee this, because that's what my ex would do with all his charges. And me, I didn't know any better. I'm not trying to say like that it's all his fault or anything. I did know better, but I was scared of being homeless and all that. So I joined the carnival, and I've been doing that for the last year and a half. I'm finally done with that and done with my ex, and I want to just be with my family. And I just found out I'm pregnant, and I want to, get out as soon as I can so I could get a job and start providing for this potential baby that I'm having,
Okay. Ms. Broadnex, Mr. McDaniel made a comment about your prior criminal history that doesn't match what I've got in front of me. So it sounds like there may be something you haven't told him about. So I'm going to ask you, when's the last time you were charged with a crime?
In Boaz, Alabama. And then I got picked up on a warrant in Georgia.
Okay. When was the last time you were charged with a crime? That's what I'm asking you, the last time.
Like Illinois, maybe. I was like
3 days after Christmas. 3 days after Christmas last year. Do you remember a burglary in Lake County? Looks like IN. That may be Indiana. Do you remember that one?
Yep. No, I do.
Okay.
I didn't at the moment, sir. I'm so sorry.
Yeah. So, Mr. McDaniel, I think there's some criminal history. There may be some more things on here that's more than just what
I
she's
forgot
got in
about
Florida. So anything else you want me to be aware of, ma'am?
I am sorry, I forgot about that one. That wasn't even, it's criminal trespassing. What is on there, right? Is on there as
It
well?
was burglary, but it may have been reduced to something else. I don't show a disposition. I don't know.
So my ex that I was with, he brought me back to Indiana when we were on winter season from the carnival. And he thought it was a good idea to break into his mother and stepfather's house they were selling because we had nowhere else to go. And so that's what happened. I got caught up on that and
Is the
I have
eggs
no
that you
idea, to be
keep,
honest.
the eggs that you keep referring to that you're blaming for a lot of your troubles, is that the same person who was with you at the dollar store in the current case?
Hunter James Polly, yes.
Okay, and in the current case, you told the officer, according to the complaint, he had nothing to do with this particular theft. That was all you. And the video
Yeah, he
seemed
didn't
to
have
confirm
anything to
that.
do with the theft. He didn't have anything to do with the theft. He
So
just got trespassing on that.
It makes me wonder who is the bad influence on whom. If the video shows you stealing stuff and him being in the store and paying for his, but now you're telling me he's the bad influence. I'm not fully convinced of that. Anything else you think I need to know, ma'am?
I mean, the last time I was here, if you look at my IDs, I had marks all over my body. They were trying to get me to admit domestic violence at the time with him, but I wouldn't because I was still in love with him. I was just doing as I was told in that time, Your Honor.
Okay.
Yes. I just asked
Thank
for a
you, ma'am.
second chance, please.
Thank you, ma'am. Mr. Mitchell, anything on behalf of the state?
Just a second, Your Honor. Nothing at this time, Your Honor.
Ms. Broadnax, having heard from you, ma'am, looked at your history and read the complaint this morning. I'm going to sentence you to 60 days in the Jackson County Jail. It's been a year. You took off, disappeared for 1 year on us. I would be foolish to put you on probation and think you're going to show back up. So I'm going to sentence you to 60 days in jail. I'm going to give you credit for the time that you've served. You're entitled to that credit. Mr. McDaniel, how much time is that?
3 days jail credit.
3 days credit, Miss.
3 days.
I'm sorry, I couldn't hear you.
I was hoping Your Honor might consider 30 days. That's what my hope was, and that's up to you.
60 days in jail is her sentence. 3 days credit. Court costs and fines are imposed in the standard amount of $370. No probation involved, Ms. Broadnax. I do wish you the best, ma'am, but I'm not convinced by your testimony or your arrest since this incident that you've rehabilitated in a significant manner. I do appreciate you turning yourself in, but it's a year too late. So, Ms. Broadnax, I wish you the best, ma'am. I'm not going to any restitution given the jail sentence. It was 2 bottles of wine. The officer didn't even put the amount of the wine in the complaint. So I'm not sure. It could have been a first degree misdemeanor, but the officer chose not to tell us the amount of the wine that was stolen. So Corporal, that's everything I had on my list. Anything else from the jail this morning?
No, sir. Just to let you know, they ain't no wine at the dollar store worth over $100.
I have no idea. I'm not a drinker. So they don't have a wine. It was 2 bottles. So they don't have a wine on the shelf that costs more than $50. But don't shake her head no, and she would know for sure. So I'll take y'all's word for that.
We'll have wine that costs more than $5. Just to let you know. So, yeah.
Okay. All right. Thank you for letting me know that. Mr. McDaniel, anything else from the Public Defender's Office?
No, Your Honor.
And 2 cases are now called. Cause numbers 23 CR 1411 and 23 CR 1838. Motions to revoke unadjudicated probation in the cases of the state of Texas versus Adrian Jacob. You were Mr. Jacob.
Yes, sir.
Present with Mr. Adams, you were attorney and the state's attorney. Does the defendant waive formal readings of these motions to revoke unadjudicated probation in 1411 and motion to revoke probation, which I guess was regular probation, in 183A? Can we proceed in summary?
Yes, sir.
Okay, I don't see any agreements.
He's gonna plead true and he's gonna go to you, but I think the state is gonna make a recommendation.
All right.
The state is gonna make a recommendation.
And in summary, and by the way, raise your right hand, sir. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth? So help you guys. Lower your hand. In summary, 1411 states that on March 31st, 2025, in this court, you were placed on 10 years deferred or unadjudicated probation for the second-degree felony of aggravated assault with a deadly weapon. Is all of that true and correct, sir? Allegation 1 states you committed the offense of theft on or about April 6th, 2025, which would have been a week after you were placed on probation?
Right.
In violation of your probation order here in Jefferson County, Texas. Is that true or untrue?
Yes, sir. He says true.
2, you failed to report to the Jefferson County Probation Office since being on probation on March 31st of 2025. Were you arrested earlier on this, or was there a period of time that he did not report until he gets arrested? How long? You were supposed to report monthly.
Yes, sir.
And did you fail to do that?
Yes, sir.
When did you finally get arrested? Do you remember?
I remember that.
I would. It would be important to me.
I got arrested on the 3rd, October 3rd.
October. Okay. So you were supposed to report, you were placed on probation on March. So you would have had to report April, May, June, July, August, September, and then in October you get. So what's that? 7 months go by that you didn't report. Is that true? About? It's 6 or 7 months.
Yes, sir. Yes, sir.
Oh,
Yes, sir.
so is that allegation true and correct?
Yes, sir.
I'm going to stop at that. Okay. Are you pleading true to allegations 1 and 2
Yes, sir.
of this motion to revoke probation voluntarily, knowingly, intelligently, and because those are true as they are alleged?
Yes, sir.
Do you understand that a voluntarily and knowingly made plea of true to 1 or more violations of probation, that is enough to grant a motion to revoke probation? Your probation can be revoked. You can now be found guilty and sentenced no less than 2, no more than 20 years confinement in prison, since this is a second-degree felony. Knowing, understanding, and appreciating all of that, do you insist on pleading true today to these violations?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true to violations of probation.
Yes, sir.
Let's hold that in abeyance. Okay, go to 23 CR 1838. Again, does the defendant waive a formal reading of this motion? Can we proceed in summary?
Yes.
And again, you're under oath, sir. In summary, this motion filed on September 29th, 2025, as well as the previous motion, it states in this other case that on March 31st, 2025, the same day you were placed on probation in the aggravated assault with a deadly weapon, second-degree felony case, that you were sentenced to 2 years in this court in the state jail, probated for 5 years for burglary of a building. Is that true?
Yes, sir.
And allegations 1 and 2 are the same. That number 1, as before, the previous case, you committed the offense of theft on or about April 6, 2025 in Jefferson County, Texas, in violation of your probation condition 1 and 2. You failed to report to the Jefferson County Probation Office in violation of condition 4 of your probation supervision order by absconding in April and not being arrested until several months later. Are allegations 1 and 2 true as well as they were in this previous motion to revoke probation?
Yes.
Are you pleading true to allegations 1 and 2 as well in this case?
Yes, sir.
Are you doing that voluntarily, knowingly, intelligently, and because this is true,
Yes,
as
sir.
it is alleged? And again, do you understand that a voluntarily and knowingly made plea of true to 1 or more violations of probation, that is enough to grant a motion to revoke probation by a preponderance of the evidence or greater? Your probation could be revoked in this case, and you could be just sentenced to no less than 180 days up to 2 years in the state jail. Yes, sir. Knowing that, do you insist on pleading true as well today? Yes, sir. I find you are pleading true voluntarily. In each of these cases, you understand and appreciate the consequences of pleading true and how that might make you vulnerable to revocations of these probation orders in each case. There is no agreement in each case?
Well, we come to you.
All right, go ahead.
Judge, I know that you just pointed out specifically the time.
Report? I'm going to look at the pre-sentence report while you're talking, okay?
I noticed you pointed out the time frame from the point that he got on probation to the point of this violation. But I think we're asking the court to take into consideration why it happened so fast. He was homeless, and talking to him, the object stolen, it's not like he was stealing a car or going stealing something major. To my understanding, it was buckets of water, not buckets, but bottles, cases of water. And the reason that he was getting that water that he was stealing, is that he was destitute and homeless at the time. At the time, he was destitute and homeless. And Judge, we're asking you to have mercy on him because, like I said, this is not a situation where you got a guy going into dealers and let's say he's stealing a bottle of cologne and resell it. And I totally get that. But this is a situation where he was destitute, he was homeless, and it was for his needs, his bodily needs, which would be water and cases of water. And Judge, I spoke with the prosecutor on this case as well. What I'm asking is that if you just give him one more shot, leave him on probation. I do believe to get him out of the hole that he's in terms of his economics, he will be able to get a job, right?
I have somewhere to stay done.
And he has a place to stay. And I believe some of his family members are gonna step up this time for him. Yes. So just looking at the nature, and he's accepted responsibility on the theft case.
Yes, sir.
On that theft case, Judge, if I'm not mistaken, and you can look at your file, I believe the misdemeanor court put him on probation for that theft. So in the misdemeanor court, they gave him probation. And who was your judge on that? That was Holmes.
Mm-hmm.
Okay, I believe it was Judge Holmes.
Yes, sir.
So, Judge, what we're asking for is for you to continue him on supervision, move the case today, and consider his economic situation at the time, and that's why it happened so fast. And also consider the object that was stolen was not an object of, personal gratification. That's what he's telling me.
Yes.
At least that's what he told me.
Okay.
So that's what he told me.
But he was placed on probation for
That's what you said you told me. Cases of water. That's what you said.
in 1411 that the defendant broke into the victim's truck, and that then he was armed with a knife and cut the man, is what he's alleged in this aggravated assault with a deadly weapon.
Yes, sir.
And
Those was the MTL people further the building.
he was later arrested and for the stabbing incident and indicted and placed on probation for that aggravated assault of March 31st of 2025. In September, they Police go again to Crystal Apartments on Gulfway Drive. Oh, 2 blocks away from the previous incident. And on September 5th and 23. And go to a theft that's reported where the victim reports that he stores industrial and commercial paint sprayers in a storage building, and surveillance video was acquired by the police who show the defendant and another person stealing those items as they are in a Chevrolet sedan with no license plates on the front or rear of the car. They back into a spot. He and another person get out, steal the sprayers, then take off. And then Mr. Jacobs apparently is known by the Port Arthur Police Department, and he was recognized. And that apparently that there were 2 thefts of the sprayers on the same day at that same location. And police find the defendant, Mr. Jacobs, and he admits being involved with it. And so he's placed on probation in these 2 cases of aggravated assault and burglary of a building. He's placed on probation and given another chance in spite of the fact that he has how many prior felony convictions of burglaries and forgeries? How many? So, because I want to, there's so many, I want to know if you can recall how many you have been convicted of.
I can't, sir.
You can't even remember. What does that say? I know of 7 burglaries of homes and back to 91. A burglary of a habitation, somebody's home. 3 years later, you're convicted of another burglary of habitation. You get 15 years in prison. Then in 94, you're also sentenced burglary of a building, 15 years, because I guess it was enhanced because of the prior conviction. In 2000, another burglary of a building, 3 years in prison. Forgery in 07, a year in jail. Burglary of a building in 09, convicted, 6 years in prison. Then in 23, you were convicted of burglary of a building in January of 23. So those are the felonies. And let's not forget, I'm looking at a page full of misdemeanors, which are deep driving while license suspended, driving while intoxicated, theft, burglary of a building, of a vehicle, burglary of a vehicle. Anyway, so those are 4 convictions of misdemeanors, 7 convictions of felonies. And then now we have these 2 revocations. We're back. And it's as though everybody is spinning our wheels. I mean, you're not only continuing to commit a crime, and just not reporting. And hold on, let me just,
Yes, sir.
this, you keep talking about water, but the administrative hearing doesn't say that, Langston. It says that on April 6th of 2025, the date that this theft occurred, allegation one that he is admitted to, it states he committed theft on or about 4/6/25, stealing someone's wallet containing about $1,000 in cash, a debit card, and insurance cards at a local HEB grocery in Port Arthur.
And what did he said, right, and Judge, I talked to him directly. He's saying that he had nothing to do with that. He's telling me that, didn't you tell me it was water?
Yes, sir.
I heard him correctly, Judge. He told me that it was water, that he was stealing because he was destitute and he needed bottles of water to drink. Isn't that what you told us? Judge, that's what he told me.
That's what the administrative hearing states is what this is. Okay. So now I've got a police report to look at your Sunday, on April 6th. There's on arrival on 4/6 at 21 at 9 p.m. Officers respond to Gulfway Drive at the HEB. Made contact with a manager who advised me one of the customers had her wallet stolen. I watched the video footage from the store, and then the video shows a male black approaching the victim near the produce area. She had her wallet on top of her cart. The suspect is observed walking toward her shopping cart as she's getting some produce. Facing away from the shopping cart, the suspect reaches for the wallet, which is on top of the shopping cart, and continues and then conceals it in the pocket of his sweatshirt. The suspect left the store shortly after, got in a passenger front seat of a dark green Chevy Trailblazer with no front license plate. The victim I was advised the victim had $1,000 in cash or debit card, as well as an insurance card for her children. She did wish to press charges. I spoke with the manager. Manager advised that the video had already been tagged, and then that's all it says on that. On April 8th, 2 days later, Detective Thomason with Port Arthur PD receives the case for follow-up investigation about the HEB theft. Let's see. The surveillance was played, captures the suspect taking the wallet, provided me Ramirez provided me a video and printout of the transaction. The name, let's see. The surveillance was played back. It captured the suspect taking the wallet. The suspect is a light-complected African-American with short hair. The same male bought items and used a card. Investigator Ramirez provided me the video and a printout of the transaction with the male suspect. The name on the transaction is Adrian Jacob. I am very familiar with Jacob. I've known him for many years through my employment as a police officer at the city. I personally filed many cases against him. I reviewed the video. There is no doubt the suspect is Jacob, not only by his face, but he has a distinctive limp and is noticeably bow-legged. All right.
So you told me that it was water.
Yes, sir.
So I guess the question the judge is raising is that based upon what he read, was that you?
Are you pleading true to these or not?
Yes, sir. Yes, sir.
He pleading true. He said he pleading true to still.
All right. Well, then you can't say I'm guilty, but I didn't do it.
Yes.
So are you saying that you're
Yes,
guilty?
sir.
He's saying he's guilty. Judge, I'm not misremembering. He told me it was water. That's what he told me.
That's what you can see. It's not a necessity of life here. This,
I'm just doing what you told me.
I know. I know what you're saying, but we're going to clear the record up.
Yeah.
It's somebody's wallet and ID was used, and that was used to forge and commit theft. That's on that case, and then we have the burglary of a building. No matter, but so the defendant has pleaded true in each of these cases and admitted culpability. So the question is, what do we do in the aggravated assault? He is looking at no less than 2 nor more than 20 years confinement in prison. I think there was a loss of $700, wasn't it?
Your Honor, in the burglary of a building, it was actually $7,000.
Was $7,000?
Yes, Your Honor.
But in this one, the wallet contained approximately $1,000 in cash.
Yes, sir. And he's currently, I believe, on probation and misdemeanor court for that offense.
Well, how does he pay it back if he goes to prison for 20 years?
And Your Honor, our recommendation, and we normally wouldn't do this, but he did cooperate and testified recently in a case for the state involving a serious offense, would be to revoke him on the aggravated assault, keep him on a straight probation.
How can I do that?
Well, it'd be then to keep him on the deferred there for the ag assault and sanction him to the max. But
so you want to just sanction him? What would be the sanction?
The 180 days.
I mean, I'll take out all of that into account, but no, I'm not. With his splendid and rich criminal history and continued, I mean, we're talking about aggravated assault with a deadly weapon here, where cutting somebody with a knife but okay, we've got this second-degree felony and then this state jail felony. What are you saying?
Well, Judge, and piggybacking on what the state just said, one thing we're asking you to give him credit for is that he apparently did testify.
And he's going to be rewarded
for cooperation.
He'll be rewarded with what I have in mind, but I want to hear what your thoughts are.
I would want him to continue on probation and give him a second shot. But
it's hard on something like this when we're talking about a aggravated nature and then the burglary of a building. But he knows that actions have consequences, and the court is going to treat him with and give him credit for the cooperation he made. The problem you have, though, is that you can cooperate all day long. And did he testify in a trial?
Yes, Your Honor.
See, the problem is that when all of these prior convictions come out, the jury can't show a lot of credibility to someone because all of that comes out. And the law states that the jury can consider prior convictions against the credibility of someone so that their statements have less value of believability than they would otherwise by somebody who's doesn't have convictions of felonies. And so you may have helped, but I can guarantee you, I know how juries are. If all of these felonies came out, and maybe they didn't, maybe the other side didn't bring them out. And if they didn't, then they don't know about it. But I know it. And it would only make sense that the defense attorney would at least challenge his criminal history in front of the jury and then argue that he's not worth credible belief because the law says that can be taken into account.
I apologize, but actually can't give me another chance.
Sir, you've had 7 or 8 separate chances here. We talked about how many prior felonies, 7, and then misdemeanors, and then here we're still committing crimes. All right, anything else to add?
No.
And the court is going to take into account your cooperation. I'm going to find that there is sufficient evidence supporting each of these motions to revoke probation in cause numbers 1411 and 1831 to grant the motions by a preponderance of the evidence or greater, as the defendant has pleaded true voluntarily, knowingly, intelligently to the offenses alleged or the allegations of violations. Number one, in each case, committing the offense of theft on or about April 6, 2025, and we cleared up what that was about. It wasn't water. It was committing the theft of somebody's wallet and money of $1,000 and ID. And then allegation number 2, failing to report, as the defendant was placed on probation and never reported, and for probation as ordered. And thus, those are violations that he has admitted to. They're proven by preponderance of the evidence or greater. And these motions, the motion to revoke unadjudicated probation in 23 CR 1411 is hereby granted. And the motion to revoke probation in 23 CR 1838 is also hereby granted. So your probations are revoked in each case. In this first case, 1411, where you were placed on 10 years deferred or unadjudicated probation, earlier in that case, you pleaded guilty to that second-degree felony voluntarily, knowingly, intelligently. There was sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt, even though that case was that final finding of conviction and sentencing of confinement up to 20 years was deferred. That deferred probation has been hereby revoked by this court based upon these violations of probation. You were hereby found guilty beyond a reasonable doubt of that underlying offense, and you were sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 2 years. And you will be given credit for all time you've served. And there's an affirmative finding that a deadly weapon, namely a knife, was used in that offense. In 23 CR 1838, your probation has hereby been revoked in that state jail felony of burglary of a building where you were sentenced to 2 years in the state jail. That was probated for 5 years. And your probation in this burglary of a building case in 1838 is revoked, and you were hereby sentenced to confinement in the state jail for 180 days. These 2 sentences shall run concurrently. You understand what has happened today? Yes, you've been given the minimum sentences because of your assistance to law enforcement.
Yes.
The order also shall reflect in cause number 1838, the 180-day sentence restitution is ordered and the judgment in the amount of $7,000. That's what was ordered in the first place. Restitution will continue. We're going to take care of victims, and that will be part of the judgment. Do you understand what has happened today, sir?
Yes, sir.
You did get reimbursed for your cooperation
Yes, sir.
that the state claims was helpful.
Yes, sir.
But still, you have to atone for the wrongful actions that you made. And I think fashioned a method that shows award. But please learn from all of these. These are now 2 more convictions. That means 9 felonies. That's far too much, sir. Your legacy in life should be doing good things, not being an habitual felon. Please do better. Langston, anything else you want to add?
Nothing from the state.
And we are in recess. Thank you. Appropriation.